Shkreli?
Yes, sir.
See, there you can answer some questions. That one didn't incriminate you. I just want to make sure you understand you are welcome to answer questions, and not all of your answers are going to subject you to incrimination. You understand that, don't you?
I intend to follow the advice of my counsel, not yours.
I just want to make sure you're getting the right advice. You do know that not every disclosure can be subject to the Fifth Amendment assertion. Only those that are that you reasonably believe could be used in a criminal prosecution or could lead to other evidence.
I intend to use the advice of my counsel, not yours.
Do you also understand that you can waive your Fifth Amendment right? You gave an interview to a television station in New York where, if I understood you correctly, you couldn't wait to come educate the members of Congress on drug pricing, and this would be a great opportunity to do it. So do you understand you can waive your Fifth Amendment right?
On the advice of counsel, I invoke my Fifth Amendment privilege against self-incrimination and respectfully decline to answer your question.
Well, Mr. Chairman, I'm vexed. He's been willing to answer at least one question this morning. That one didn't subject him to incrimination. I don't think he's under indictment for the subject matter of this hearing. So the Fifth Amendment actually doesn't apply to answers that are not reasonably calculated to expose you to incrimination. And even if it did apply, he's welcome to waive it. And I listened to his interview, and he didn't have to be prodded to talk during that interview. He doesn't have to be prodded to tweet a whole lot or to show us his life on that little webcam he's got. So this is a great opportunity if you want to educate the members of Congress about drug pricing or what you called the fictitious case against you, or we can even talk about the purchase of is it Wu-Tang Clan? Is that the name of the album? Name of the group?
On the advice of counsel, I invoke my Fifth Amendment privilege against self-incrimination and respectfully decline to answer your question.
Mr. Chairman, I am stunned that a conversation about an album he purchased could possibly subject him to incrimination. But if
well, the gentleman is correct. I understand that Mr. Shkreli is under indictment, but it is not the intention to ask him questions about that topic.
So if I understand it correctly, we're not going to ask him questions that are going to be in the subject matter of his current pending criminal charges. And if we were to get close to one or in the gray area, he's welcome to assert his Fifth Amendment privilege there. And if we stay away from the subject matter of his indictment, he is, some could argue, has a legal obligation to answer under Kastigar versus United States, but certainly has the right to do so, as he did in the television interview and as he does quite frequently on social media.
Correct. Trying to.
Mr. Chairman, may I be recognized for a moment?
No, you will not. No, you're not allowed to. Under the House rules, you have not been sworn in.
Thank you, Jimmy. We will not waver in our commitment to see that justice is done for this terrible act in Benghazi. And make no mistake, justice will be done. That was the President of the United States over a year ago. We're investigating exactly what happened. But my biggest priority now is bringing those folks to justice. That was the President of the United States over a year ago. No one has been arrested. No one has been prosecuted. No one has been brought to justice. We don't even have access to the witnesses. You and the media were good enough for my 16 years as a prosecutor not to tell me how to do my job. And so far in Congress, y'all have been good enough not to tell me how to do my job. I'm not telling you how to do your job. But I'm going to ask you some questions, and if you can't answer these questions, then I'll leave you to draw whatever conclusion you want to draw about whether or not the media has provided sufficient oversight. Can you tell me why Chris Stevens was in Benghazi the night that he was killed? Do you know? Does it bother you whether or not you know why Chris Stevens was in Benghazi? Do you know why we were the last flag flying in Benghazi after the British had left and the Red Cross had been bombed? Do you know why requests for additional security were denied? Do you know why an ambassador asking for more security days and weeks before he was murdered and those requests went unheeded? Do you know the answer to why those requests went unheeded? Do you know why no assets were deployed during the siege? And I've heard the explanation, which defies logic, frankly, that we couldn't have gotten there in time. But you know, they didn't know when it was going to end. So how can you possibly cite that as an excuse? Do you know whether the president called any of our allies and said, can you help? We have men under attack. Can you answer that? Do any of you know why Susan Rice was picked? The Secretary of State did not go. She says she doesn't like Sunday talk shows. That's the only media venue she does not like, if that's true. Why was Susan Rice on the 5 Sunday talk shows? Do you know the origin of this mythology that it was spawned as a spontaneous reaction to a video? Do you know where that started? Do you know how we got from no evidence of that to that being the official position of the administration? In conclusion, Congress is supposed to provide oversight. The voters are supposed to provide oversight. And you were supposed to provide oversight. That's why you have special liberties, and that's why you have special protections. I am not surprised that the President of the United States called this a phony scandal. I'm not surprised that Secretary Clinton asked, what difference does it make? I'm not even surprised that Jay Carney said Benghazi happened a long time ago. I'm just surprised at how many people bought it. A potential witness in an investigation, she recuses herself. Someone in the Department of Justice had to decide to pass out these immunity agreements. And I see they get out of jail free cards, Brett. What I don't see is the jail. Usually you strike immunity agreements to further a prosecution. There is no prosecution. It's just 5 get-out-of-jail-free cards. Number one, if you think that there is evidence that is relevant to an investigation on a piece of physical property, you use a subpoena, a grand jury subpoena. You don't strike an immunity agreement with the computer. You go get the computer. Her lawyer, Beth Wilkinson, who, by the way, represents both Heather Samuelson and Cheryl Mills, she's on record as saying the Department of Justice assured me my clients did nothing wrong. Well, people who've done nothing wrong typically don't ask for immunity. So my question would be, immunity from what? What was it that you were worried about the FBI finding on those computers? And Brett, I'll tell you what I think it is. She had classified information on those computers. So you offer immunity to Cheryl Mills, who has classified information on her computer. How can you possibly then prosecute Hillary Clinton for having classified information on her computer? You couldn't do it.
So are you saying, Congressman, that there was no intention at the beginning to prosecute Hillary Clinton, no matter what happened?
Well, I don't want to malign the FBI, but I can tell you this. I have been underwhelmed by an agency that I once had tremendous respect for, and it's the Department of Justice who gives out immunity agreements, not the FBI. The FBI doesn't immunize anyone. But the Department of Justice, the same department that is headed by someone who met on a tarmac for half an hour to discuss golf and grandkids with a potential witness, to say nothing about being the spouse of a target.
That Hillary Clinton's former chief of staff, Cheryl Mills, and 2 other staff members were granted immunity in exchange for cooperating with the FBI. Apparently, Chafis describes this immunity as saying that Mills gave the federal investigators access to her laptop so that she would not have any charges against her. That was the exchange. He went on to say, quote, no wonder they couldn't prosecute a case. They were handing out immunity deals like candy. He was referencing, of course, other immunity that was granted to the person that set up the server for Hillary Clinton, as well as the person that was supposed to erase the emails. So that is being reported by the Associated Press. Fox News has confirmed it as well. Surely Congressman Chafis will have more to talk about it, but we're getting a picture of exactly what happened during this FBI investigation and seeing who was granted immunity. And of course, when you're granted immunity, the FBI cannot use.
Is when you have a fact pattern of someone spying on another person while they are taking a shower. You don't need a policy change, and you don't need a new memo. You need handcuffs and a trip to the sex offender registry. That's what you need. So, Ms. Martin, you said a couple of things in your statement that resonated with me. You said it is a deep, conflicted, and risky decision for me to come forward and speak up today. And you said many women feel shame and fear of coming forward to report misconduct and cannot bring themselves to be the ones who have the difficult and painful task of speaking up. Here's what I want you to help me do. I want the fear and the difficulty and the pain to belong to the perpetrator, not the victim. So I want you to tell us as much about your fact pattern, your story. And I want you to stop and cite all those instances where something more could have been and should have been done. And do it on behalf of the women who maybe don't have the ability to speak up like you do.
Thank you, Congressman, for this opportunity. It is a very painful and conflicted position that I'm in right now. This happened. I was a victim of Peeping Tom at Grand Canyon in 1987. It was a very difficult and painful experience for me. I reported it to 2 supervisors immediately that first day, that I was able to positively identify a park ranger in uniform that was peering through my bathroom window. I reported it to 2 supervisors, visibly shaken. It was very, very difficult for me to do. It was very embarrassing. I didn't think anybody would actually even believe me that something like this had happened to me. I was given options. I could say nothing and move on. I could file an EEO complaint or a criminal complaint. I had to think about that for a couple of days as to how I wanted to proceed. I was just starting my career in the federal service in my early 20s, and I just did not want to make this an issue. I just did not want to come forward and admitting a complaint like this early in my career and be labeled as a troublemaker. In the end, what I agreed to was a conference or a sit-down with the 2 supervisors that I reported this to, along with the perpetrator. He apologized to me. He assured me that this had never happened before and that it'll never happen again. And so for me, this has been with me my entire career. And so when I think of zero tolerance, I think this is where this was the hardest part for me, it just did not feel like zero tolerance for me. I've had to live with this a long time. This particular individual continued to be moved through the Park Service and just recently retired. So for me, I believe that this was the tipping point for me to come forward and tell my story, that this is why I could no longer remain silent. There's a lot of other women out there that I represent that these very same things have happened, or very similar things, and they just fear that management will not take action, and then we become victims again for coming forward.
So the perpetrator went on and finished his career with the Park Service and is now enjoying the perks of his retirement?
That's my understanding.
Well, I'll just say this. You should never have to choose between your career and justice, ever. You should be able to pursue both of them with all the vigor in the world. So I'm sorry it happened to you, and I appreciate the courage it takes to come and share your story. Oh, no, 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 no. We cannot second guess. That is the one entity in this republic that can never be second guessed is the FBI. I find that fascinating, particularly coming from as many criminal defense attorneys as we have on the other side who made a dadgum living questioning the FBI. I mean, that's how they made their living, is second guessing the FBI. But no, once you take the oath of office for Congress, whatever they do, you don't want to prosecute the big banks, FBI, we're fine with that. You don't want to do anything about the people who committed fraud during the housing crisis, we're fine with that. God forbid we ask the FBI anything. All I want to know, Mr. Chairman, is did you give immunity to the person who destroyed federal records after a subpoena was in place? That's a fair question, and I would think every member of Congress would want to know the answer. So issue number one is, do you have to come? Issue number two is whether or not you have to talk. And unless your name is Jack Bauer, you cannot force anyone to talk. Now, we can have a robust debate about whether or not this witness has been immunized. I read the immunity agreement. And what I find interesting is the doublespeak that I hear from some of my colleagues. You cannot, in one sentence, say DOJ has refused to prosecute, that this is a nothing case, and then the next sentence say you're worried that DOJ is going to prosecute. Congress cannot prosecute anyone for anything. Nothing. The only entity in this country that can level criminal charges is the executive branch. And they have already said they're not going to do so. So where is his criminal exposure? Where is it? Unless they're going to say, Mr. Chairman, that we are worried that he is going to make a false statement before Congress. Now, that would be interesting if that's the argument. We are worried that this witness who cooperated with the FBI may tell Congress something different. Well, guess what? The agreement he has with the Department of Justice requires him to be truthful. So you would want people to say the same thing to Congress that you say to the FBI. This is what I find most interesting of all. The Department of Justice has already said they're not going to prosecute anybody for anything. This matter is closed. Nobody's going to be prosecuted. But I'll bet you that agreement allows for this witness to cooperate with other entities of government. In fact, in the old days, it required that witness to cooperate with other entities of government. And I'll tell you why, Mr. Chairman. I have sat while some of the very members who are sitting in this room right now provided oversight over the FBI, over national security letters. They didn't give one whit second thought about second-guessing the FBI and the issuing of national security letters. I mean, who else would provide oversight over the FBI if not for Congress? And I listened to some of the very same members on this committee provide oversight over the Department of Justice, over the prosecution of Ted Stevens. So they have no problem providing oversight over the Department of Justice when they don't like the outcome. But when they do like the outcome,
the FBI released more notes on its investigation of the former Secretary of State. One of the findings? President Obama used a pseudonym to email with Clinton on her non-secured server. That raises questions about this previous claim from the president.
Mr. President, when did you first learn that Hillary Clinton used an email system outside the U.S. government for official business while she was Secretary of State?
The same time everybody else learned it through news reports.
During its investigation, the FBI showed one of the exchanges between the secretary and the president to Clinton's top aide, Huma Abedin, and she reportedly expressed shock, exclaiming, "How is this not classified?" The agency says Abedin then expressed her amazement at the president's use of a pseudonym and asked if she could have a copy of the email.
Including.
Well, we just heard from the White House a short time ago.
The White House thinks that it was appropriate for the FBI to offer the immunity to those three individuals.
Josh, off the top of my head, I can't recall an instance in which I second-guessed the decision made by the FBI director or an independent investigator at the FBI, and I'm not going to start today.
The Clinton campaign also released a lengthy statement after this reporting became public, accusing congressional Republicans of overblowing, the agreements. It reads in part, "This kind of agreement is not as unusual in such an inquiry as this," and it came after these aides had already given full interviews to the investigators, and the House Government Committee senior Democrat Elijah Cummings said Republicans will stop at nothing to tear apart the FBI's independent investigation to try to damage Secretary Clinton's presidential campaign.
Including.
Well, there was a cover-up, and the folks who aided and abetted that cover-up is the State Department. I mean, keep in mind, Brett, she had this arrangement for the entire time she was Secretary of the State. Then she kept her emails for almost 2 years, and it was only because a congressional committee would not go away that the State Department bothered to ask her to return the public record. And then that's when it gets interesting. The conversations between Cheryl Mills and Patrick Kennedy, and then Platte River, and then we send a subpoena, and Platte River destroys documents after the subpoena. The State Department, which is supposed to be apolitical, not interested in the next presidential election, has been covering for Hillary Clinton since she left office.
Including.
Well, what about the Department of Justice offering this at least partial immunity, but immunity through the FBI to 5 different people, one of them, Cheryl Mills, the former chief of staff of Hillary Clinton? For a lot of people who looked at this, they just don't get that.
Yeah, and I would be one of them who don't get it for a couple of reasons. Number one, if you think that there is evidence that is relevant to an investigation on a piece of physical property, you use a subpoena, a grand jury subpoena. You don't strike an immunity agreement with the computer. You go get the computer. Her lawyer, Beth Wilkinson, who, by the way, represents both Heather Samuelson and Cheryl Mills, she's on record as saying the Department of Justice assured me my clients did nothing wrong.
Including.
Well, people who've done nothing wrong typically don't ask for immunity. So my question would be, immunity from what? What was it that you were worried about the FBI finding on those computers? And Brett, I'll tell you what I think it is. She had classified information on those computers. So you offer immunity to Cheryl Mills, who has classified information on her computer. How can you possibly then prosecute Hillary Clinton for having classified information on her computer?
Including.
You couldn't do it.
So are you saying, Congressman, that there was no intention at the beginning to prosecute Hillary Clinton, no matter what happened?
well, I don't want to malign the FBI, but I can tell you this. I have been underwhelmed by an agency that I once had tremendous respect for, and it's the Department of Justice who gives out immunity agreements, not the FBI. The FBI doesn't immunize anyone. But the Department of Justice, the same department that is headed by someone who met on a tarmac for half an hour to discuss golf and grandkids with a potential witness, to say nothing about being the spouse of a target, a potential witness in an investigation. She recuses herself. Someone in the Department of Justice had to decide to pass out these immunity agreements. And I see they get out of jail free cards, Brett. What I don't see is the jail. Usually you strike immunity agreements to further a prosecution. There is no prosecution. It's just 5 get-out-of-jail-free cards.
Including
Recommending to the House of Representatives to find Brian Pagliano in contempt of Congress for refusal to comply with a subpoena duly issued by the Committee on Oversight and Government Reform. Our first and only item for consideration today is a resolution and report recommending that the House of Representatives find Brian Pagliano in contempt of Congress for refusal to comply with a subpoena duly issued by the Committee on Oversight and Government Reform. The clerk will designate the report.
Resolution recommending that the House of Representatives find Brian Pagliano in contempt of Congress for refusal to comply with a subpoena duly issued by the Committee on Oversight and Government Reform.
I intend to offer an amendment in the nature of a substitute to the report, and without objection, we will call up the amendment in the nature of a substitute, and then I will recognize myself to give one statement on both the ANS and the underlying report. The clerk will designate the amendment.
Amendment in the nature of a substitute offered by Mr. Chaffetz of Utah to the resolution recommending that the House of Representatives find Brian Pagliano in contempt of Congress.
Without objection, the amendment is considered as read, and I now recognize myself for 5 minutes and a statement to report on the report and the ANS. Today, the committee will consider a resolution and report recommending Brian Pagliano be held in contempt of the House of Representatives. Subpoenas are not optional. Mr. Pagliano is a crucial fact witness in this committee's investigation of former Secretary of State Hillary Clinton's use of a private email server to conduct government business. The release of these Federal records is of deep concern to the committee, and we have the jurisdiction over Federal records. We have jurisdiction over National Archives. We have jurisdiction in several places. Over the course of the investigation, we learned some of the information about Mr. Pagliano's involvement in Secretary Clinton's use of the private server. Mr. Pagliano originally worked for Secretary Clinton in her 2008 presidential campaign as an IT specialist. As he was closing out her campaign's computer equipment, he received a call from Justin Cooper, who testified before this committee last week. It was Mr. Cooper who requested Mr. Pagliano build a server for Ms. Clinton in early 2009 as she started her new job as Secretary of State. Several months later, in March of 2009, the two men met in the basement of Clinton's Chappaqua residence to install a new server Mr. Pagliano built. Mr. Pagliano continued to monitor and maintain the server while Secretary Clinton was at the State Department. After he set up the server, Mr. Pagliano joined Secretary Clinton at the State Department as a Schedule C appointee in the Bureau of Information and Resource Management. By law, Schedule C appointees are required to report to a presidentially appointed position, but there were no presidential appointees in the Bureau of Information and Resource Management, making Mr. Pagliano's employment arrangement unusual at best. Other employees in his Bureau later questioned his ability to support a private client's email server, given his capacity as a full-time government employee. Mr. Pagliano left the State Department in February of 2013, the same month as Secretary Clinton. Even though he worked at the State Department for almost 4 years, the agency has been only able to find a handful of emails. We have questions about this. Mr. Pagliano's emails are Federal records, just like Secretary Clinton's emails, and subject to production in response to a Freedom of Information Act request. The committee has jurisdiction of both the Federal Records Act and FOIA. We also have a long record of oversight, investigative, and legislative work in this area. The committee subpoenaed Mr. Pagliano to appear at a hearing on September 13, 2016. He did not show up to that hearing. I explained Mr. Pagliano was uniquely qualified to provide testimony to help the committee better understand Secretary Clinton's use of a private email server. This is undisputable. I also made clear the committee would consider all options regarding Mr. Pagliano's failure to appear, including consideration of recommending he be held in contempt. The committee then heard several hours of testimony from Mr. Cooper, who was also involved in setting up Secretary Clinton's email server. Mr. Cooper, to his credit, explained a lot. We did appreciate his participation in answering all the questions that this committee asked. Throughout his testimony, Mr. Cooper routinely referred to Mr. Pagliano as the individual more appropriate to answer questions who knew more about the server. It was clear from Mr. Cooper's testimony, his words, not ours, that we needed to hear from Mr. Pagliano. Mr. Pagliano's attorney asserts because his client took the Fifth before the Select Committee on Benghazi, he shouldn't be required to provide testimony to this committee. That is not a good faith argument. It makes no sense for a number of reasons. First and foremost, the Select Committee's jurisdiction is limited. It only relates to September 11, 2012 terrorist attack in Benghazi. In contrast, this committee's jurisdiction is broad and includes both legislative and oversight of the Federal Records Act and the Freedom of Information Act. Questions about these two topics alone are well outside the purview of the Select Committee's investigation. Secretary Clinton's emails and Mr. Pagliano's were subject to both of these laws. Mr. Pagliano could explain what he knew or what he was told about these laws. He could tell us whether or not they were considered by him or others in setting up Secretary Clinton's private email server. Mr. Pagliano's testimony could provide important information, informing legislative reforms that this committee may want to consider, ensuring that this disaster never happens again. This includes reforms based on how he was able to prevent the State Department from locating most of his emails. Another key difference in last month, this committee had the benefit of reviewing the testimony Mr. Pagliano did provide during his interview with the FBI. The Select Committee never did see that, 302. Nor was the Select Committee aware of the thousands of classified emails that traveled over Secretary Clinton's server when they spoke with Mr. Pagliano. This committee's questions are broader and more informed than any questions posed by the Select Committee, making a comparison unnecessary. Further, answering a number of these questions could never subject Mr. Pagliano to criminal liability. The Department of Justice has confirmed Mr. Pagliano was granted immunity before he spoke to the FBI. Director Comey confirmed that he was recommending no charges be brought against anyone involved in the matter. Attorney General Lynch accepted the recommendation and closed the case. Under those circumstances, Mr. Pagliano has no fear of criminal liability, preventing him from answering questions before this committee. The committee recessed its September 13th hearing with Mr. Cooper to give Mr. Pagliano another opportunity to show up and testify. To clear up any ambiguity created by Mr. Pagliano's 6 lawyers about whether they would confirm service of the prior subpoenas, which they refused to do, we had the U.S. Marshals personally serve him. We scheduled the continuation of the earlier hearing for this morning, but once again, he failed to show. This committee cannot operate. It cannot perform its duty, nor can any committee of Congress, if subpoenas are ignored.
A potential witness in an investigation, she recuses herself. Someone in the Department of Justice had to decide to pass out these immunity agreements. And I see the get out of jail free cards, Brett. What I don't see is the jail. Usually you strike immunity agreements to further a prosecution. There is no prosecution. It's just 5 get-out-of-jail-free cards. Number one, if you think that there is evidence that is relevant to an investigation on a piece of physical property, you use a subpoena, a grand jury subpoena. You don't strike an immunity agreement with the computer. You go get the computer. Her lawyer, Beth Wilkinson, who, by the way, represents both Heather Samuelson and Cheryl Mills, she's on record as saying the Department of Justice assured me my clients did nothing wrong. Well, people who've done nothing wrong typically don't ask for immunity. So my question would be, immunity from what? What was it that you were worried about the FBI finding on those computers? And Brett, I'll tell you what I think it is. She had classified information on those computers. So you offer immunity to Cheryl Mills, who has classified information on her computer. How can you possibly then prosecute Hillary Clinton for having classified information on her computer? You couldn't do it.
So are you saying, Congressman, that there was no intention at the beginning to prosecute Hillary Clinton, no matter what happened?
Well, I don't want to malign the FBI, but I can tell you this. I have been underwhelmed by an agency that I once had tremendous respect for, and it's the Department of Justice who gives out immunity agreements, not the FBI. The FBI doesn't immunize anyone. But the Department of Justice, the same department that is headed by someone who met on a tarmac for half an hour to discuss golf and grandkids with a potential witness, to say nothing about being the spouse of a target.
So is the administration pushing a program to register more Hispanic voters so that they'll vote for Hillary?
Short answer is yes. There's no doubt that the administration is pushing the accelerator on naturalizing new citizens. They've been doing it for many months. This is only the latest evidence of that. They're being helped by pro-democratic outside groups. And look, there's really one reason for that. We have research going back many years showing that newly naturalized citizens identify with the Democratic Party over the Republican Party by a factor of about 2 to 1. That's something that's been consistent over the years, and we know that in 2012, Latino and Asian American voters, this is naturalized as well as natural-born citizens, voted 70+% for President Obama. So I think those facts are pretty much all you have to know about the motivation in this case.
I know Bernie Sanders said that, quote, the American people are sick and tired of hearing about your damn emails. But there are a lot of people who are not.
Well, let's start with Mr. Soul there. The NSA, do you have an understanding of the total universe of the compromised classified material that was found in the universe?
Absolutely not.
What? Explain that to me. Hillary Clinton took 4 years of communication outside of a secure communication. Do you or do you not have an understanding of the universe of that breach?
If by universe, sir, you mean the importance of it, I certainly understand the importance of it, but I don't have personal knowledge of everything that is said to have been released.
Does your agency, does the NSA understand the universe of the breached material?
My understanding is that every document that was referred to us, but I will want to talk more in closed session, sir, we had the opportunity to review, and I can give you the results of that in closed session.
But do you have an accounting that shows that you have all of there were untold tens of thousands of things that were destroyed? We heard testimony from Under Secretary Kennedy just last week that they now have 14,900 additional emails, plus tens of thousands that have been given to them in the last 30 days. So I'm asking if the NSA, how much classified information from NSA has been compromised in a non-secure setting?
Sir, I'd have to speculate. I do not know that, and I don't know that we do know that, but I could take that back.
And you'll get that to me by?
Sir, I'll look. I don't know. A week? Is that acceptable?
That's fair. That's fair. Mr. Samuel, same question.
Sir, while I prefer to discuss this in the closed session, yes, NGA is aware of and has reported back to Congress the extent of our equities found in those emails.
Can you give us a general sense, though, of what percentage of the compromise do you believe you're aware of?
Sir, again, I prefer to discuss that in the closed session.
Mr. Samuel, when did you first become aware that there could have been a compromise of this data?
So our agency started receiving requests last fall to look at this information in earnest, and that's when I first became aware of it.
Mr. Soul, when did the NSA first become aware that there might have been a breach of this classified information?
Sir, like my NGA colleague, I believe it was last fall, but I don't have that information in front of me.
Okay. Just so members know, that this criminal referral started because the Inspector General got word that there was classified information in a non-secure setting. They confirmed that it was in a non-secure setting, and that's when they gave the criminal referral to the Federal Bureau of Investigations. Part of what we need to understand is, when did ODNI, CIA, NGA, when did they all understand? Has all that information been recovered? We need to know whether or not ODNI understands the scope of what was potentially sent in those emails. Do you feel, Ms. Walsh, that ODNI knows 100% of what was compromised?
Given that that's outside of my role in legislative affairs, I'd have to take that back.
Can you get that to me? Is a week fine? Is that to ask that question?
We'll do our best. Is
A week,
the best
then?
I'm going to say. We'll do our best.
A week? Is that fair?
Sure.
Thank you. Appreciate it. All right. Gentlewoman yields back. Do any other members have any other questions appropriate for an unclassified setting? Mr. Gosar is now recognized.
Thank you, Mr. Chairman. Mr. Higgins, CIA collects a great deal of human intelligence. That is, it collects information from foreign individuals, often at the risk of that individual's life. Is that true?
Yes.
Are you aware that the State Department released some unclassified emails from Secretary Clinton with a FOIA redaction that said, quote, B3CIA persons /org? Are you aware of that?
I will admit I do not remember every classification marking on each of the emails that were released pursuant to the FOIA request.
So let me get this straight. So CIA persons /org means information redacted with sensitive information about an individual organization affiliated with the CIA, correct?
I will take your word for it. I don't have the FOIA manual in front of me, I'm afraid.
So if information from a single or small group of CIA officers or agents makes it to our adversaries, that could present a huge risk for their safety, right?
Sir, I wouldn't want to speculate without knowing what information we were discussing, and I'd prefer to.
But potentially, I mean, given that circumstance, it could potentially have some serious ramifications for those people.
Again, it would all depend on the information in question, and I'd prefer to discuss the classification review and any classified material in a closed setting.
Well, but that's hardly a classification that we can't talk about right here, is it?
If information relating to CIA sources and methods were disclosed to a foreign adversary, yes, that could have adverse consequences.
So to some degree, protection of classified information is life or death?
It can be, yes.
Okay. And even a few sentences from a source could reveal the source, it could expose that source, true?
It would all depend on those few sentences.
But it could?
Potentially, yes.
Okay. So would you say that someone who treats information with our spies abroad exceptionally carelessly should be trusted with a security clearance?
Sir, I think that is well outside my remit.
Well, I watched the chairman ask each one of you, gentlemen and ladies, going back over classified, did you remove any information out of a SCIF or any documentation? And those that said yes said, hey, you went back. There was some seriousness to it, right?
I believe people with access to classified information treat that responsibility seriously, yes.
You say that one more time?
I said I believe people with access to classified information treat that responsibility seriously, yes.
Really?
I do.
So why are we here?
I would defer to the chairman.
No. So why are we here? Because we have a Secretary of State that had a whole server that was offline. Kind of unusual, wouldn't you say?
Again, sir, I am here and ready to
That's
discuss
fine.
the classification
Mr. Soul,
process in a closed setting.
NSA is tasked with collecting intelligence electronically through signals. Is that correct?
Yes, sir, it's correct.
Would leaking signals intelligence damage national security?
Yes, sir, it would.
What if the person looking at the intelligence thought the information in question wasn't important? Is that a valid excuse for leaking signals intelligence?
No, sir.
Leaking any signals intelligence can reveal our signals intelligence capabilities so that even if information collected by NSA seems innocuous, is that correct?
Generally, I agree, sir. It would depend on the facts.
It still should be treated as classified, true?
If it was indeed classified and properly classified, it should be treated as classified.
Has the NSA ever lost an important intelligence collection tool, been burned, it's the quote, because classified information about that method made it into the wrong hands?
Yes.
Would you say that someone who treats NSA signals intelligence exceptionally carelessly should be